That is why
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
This is an appeal directed against the judgment and order dated 3.
Your volume, audio.
Well, it's my apologies.
Yes, Mr. Paul.
Am I audible now, Malus?
Yes.
Malus, this is an appeal directed against the order dated 3/2/2023. Malus, this matter is the matter which your lordships had the occasion to deal with earlier also, Malus.
This has been stayed by the Supreme Court, no? Not this one.
No, Malus, not this matter, Malus.
Oh, there's some other.
Malus. This matter pertains to Malus non-filing of returns by the respondent number 3, which is the Nationalist People's Party. The learned single judge, Malus, we had come on an earlier occasion before your lordships, Malus, and your lordships had directed the learned single judge to hear the matter expeditiously and dispose it of. The matter was heard, Malus, and the finding of the recorded by the learned single judge is that the writ petition is not maintainable in view of the bar under 329 of the Constitution of India. Malus.
Now that is stepped in. At the moment you have the election commission, the elections have been notified. There's no point answering this question. If you want, we'll keep the appeal after the election and then we'll take it up.
My lords, because
7 days into the left for the election day, we don't think that it is a fair time to answer this question.
My lords, I would pray your lordships have it immediately after the election.
Very good. The appellant maintains that the single bench erred in holding that the writ petition was not maintainable in view of Article 329 of the Constitution. Full stop. Paragraph, the matter requires to be looked into. Paragraph, since the state election is scheduled to be held on February 27, 2023, let this matter appear a week thereafter.
Highly obliged.
Let the appeal appear a week thereafter. Yes.
Right.
Item number 2.
One request.
Yes.
Lord Chairman, item 1. The appeal has been filed without a copy of any affidavit, or it's not supported by the affidavit of the appellant. So
It's not
I just
necessary.
wish to.
An appeal can be filed only with the memorandum of appeal. Nothing else is necessary.
Certificate.
Lord Chairman.
Only the memorandum of appeal is the appeal. The stay petition is what you take it, but stay petition is not necessary if you don't want to stay. Yes.
I'll leave it at that.
Highly obliged.
Item number 2.
Where is your restoration application? Where is your restoration application? What is the matter about Dr. Moika?
My lord, this is something arising from CAT, my lord. Earlier he filed the writ petition, my lord, and
Yes.
those were dismissed on 18/3/2021, my lord, for
Default.
non-prosecution.
For default.
For
We'll
default.
restore them.
My lord,
And we'll hear the matter on merits.
my lord, they are coming after 2 years, my lord. Certain
Let him come after 2 years. No judge likes a matter to be heard without going into the
my
merits.
lord, that part is, my lord, I admit to that, my lord. But certain statements in paragraphs, my lord, may I just point out your lordship's attention to, my lord, in this application, my lord.
When he has called me an idiot,
My lord, he
he has
uses the,
called someone a fool.
my lord, he uses the
We
word,
know that. We are restoring. We are not looking at his allegations.
my lord, the statements at least, my lord, he uses the word farcical, my lord, against this honorable court, my lord.
Let him make whatever he wants. We'll hear him on merits. We are not concerned with every person, every litigant.
My lord.
Where paragraph?
Paragraph 2, my lord. The last sentence in subparagraph 1, my lord. The said order is farcical, illegal, unconstitutional, and stands for denial of
Where
justice.
this
Para 2, subparagraph 1, my lord.
paragraph 2? We have only.
In the
How
restoration
is it during March 2021 things got dismissed for default? Matters were not disposed of on merits, yet petitions were dismissed for default. During the lockdown,
March,
18th March, the second wave was on. I remember the dates very well.
18th of March 2021.
18th March 2021, the second wave had come. By 14th March, there was panic.
My lord, but only one aspect, my lord. The matter was
One,
para 2, subparagraph 1, my lord.
he has a right to say, we don't have to take every allegation at face value or seriously. The grievance of the petitioner is that
My lord,
2 writ petitions,
3 writ petitions.
the 3 writ petitions, comma, WPCE number 69 of 29, comma, WPC number 70 of 2019, and WPC number 71 of 2019 were dismissed for default by an order dated
March 18th.
March 18, 2021, when the petitioner had been transferred to Delhi and, in any event, the prevailing lockdown following the second surge of the pandemic prevented the petitioner from prosecuting his petitions. Full stop. The petitioner, paragraph, the petitioner appears in person. Full stop. The petitioner relies on an order passed on January 23, 2023 by the Supreme Court on a petition carried to that court under Article 32 of the Constitution. Full stop. In essence, the Supreme Court observed that the petitioner's applications for restoration of the three petitions should be considered in right earnest by this court. Paragraph. No court likes a matter to be dismissed without going into the merits thereof. Full stop. As it is, citizens are reluctant to approach the court because of the notorious fact of the court's delay. Full stop. Here was a case where a central government employee had challenged orders passed by the Central Administrative Tribunal but could not stay back to conduct the case in view of his posting and the lockdown situation. Full stop. Paragraph. The union is represented and refers to some serious allegations levelled against the court by the petitioner and, indeed, some epithets used. Full stop. Paragraph. Surely, the petitioner cannot be taken to be serious in making the allegations, and the court has to be and the court has to show a degree of disregard, particularly considering that they may be words made in desperation. Full stop. Paragraph. The orders dated March 18, 2021, by which the three several writ petitions were dismissed for default, are recalled. Full stop. The relevant writ petitions are restored to the board for immediate hearing. If you are ready.
After 1 month.
Paragraph. The petitioner is invited to address the merits of the matter in the three writ petitions. Full stop. However, since the petitioner seeks a month's adjournment, a month's accommodation, let the three matters appear 4 weeks hence. Full stop. The petitioner is reminded that the petitioner need not physically appear before the court because any person can avail of the virtual mode of appearance. Full stop. The petitioner will contact the registry and get the details as to how to avail of the virtual mode of appearance. Full stop. Then give a date, 4 weeks hence. Then the applications, if there are any applications, those applications or one application or however many are disposed of, those applications. Yes. somewhere, just where we've said about the words he used. After that, in view of the circumstances in which the petitioner could not proceed with the petitions, the delay in applying for restoration is condoned in view of the good ground shown. Yes.
From the main list, item number 1.
Wait, please, Your Lordship. My Lord, this is the case, my Lord, where the Honorable Apex Court, my Lord, directed for an inquiry, my Lord, to find out whether, my Lord, my land has been acquired, whether, my Lord, I have been paid more than what I have quoted,
Yes.
Lordships. Now, my Lord, I have looked into the findings, my Lord. So far, my Lord, this is not at all correct. I will show Your Lordships.
We'll go into that. Yes.
Yes.
Who are you appearing for?
My Lord, I have been appointed as an amicus to assist
Very
the
good.
court, my Lord. I just wanted, my Lord.
Yes.
Yeah. I just wanted to point out 3 things, my Lord, and that will, though the inquiry does not very specifically say that how much should have been the market value and how much excess was paid.
The district judge conducted an inquiry.
Yes, my Lord.
Didn't we ask him to also indicate how much it was? We kind of rejected the report, and he said,
Yes, my
so
Lord.
is there a second report?
No, there is no second report, my Lord.
We had indicated over there.
Yes, my
in
Lord.
One of the
My lords
orders.
have already indicated.
Which order is that? Order dated?
The last order.
There's one order.
Yes, my Lord. That is the
19th.
15th, this is, my Lord, required by 15th November 2022. So, my Lord, type my- Oh, I'm not sorry, my Lord, that's 22nd. There's one more. My Lord, that is, I was right. That is 15th November 2022, my Lord. Where my Lord has said at page 3, the two issues which were raised in the Supreme Court.
Yes,
and then it went
found
out.
it.
Yes, my Lord.
Where is the report?
The report is of 24th November 2017. It's-
There are two ways of proceeding in the matter. One is to require the district judge who had gone through the details to give an assessment of what is the excess and to receive all the evidence in such regard, so that you have two forums. One is before the district judge. If you are happy, you rest with that. If you are not happy, you have a forum before the High Court. The other is where we decide straight away what is the quantum, and then you'll have the special leave petition available to you, but no regular forum. So you can choose.
Lordship, only thing, if I can point out, my Lord, only thing, as regarding the market price, my Lord, how it
We
has
are
been.
not into the merits of the matter, sir. We have put a very simple question. We are giving you the choice. If you want it, we can do it. We are not shy of doing it. But once we do it, you will have no right of grievance otherwise than by special leave. But
Hearing for number 2.
but if the district judge does it, then at the time that it's implemented, naturally you'll have, it's like land acquisition proceedings.
Yes, my lord.
Land acquisition, section 18.
Section 18 now.
You'll have avail of that. You will avail that.
Milord, here, Milord, what has happened, what strikes me, Milord, is that we have taken this ground also, Milord, since evidence was not taken. So I would submit the first option which your Lordship has.
Yes, evidence has to be taken.
Yes, yes.
And in matters like this, the High Court should not be the evidence-taking court.
Right.
Unless the High Court is vested with original jurisdiction,
Right.
that evidence should be taken by the district judge.
Right.
And instead of asking the gentleman who had done it, we'll ask the present district judge Riboy.
Yes.
Who is the present district judge in Riboy?
B.
Mauri.
Mauri. Yes, we'll ask the present district judge in Riboy to conduct that fact-finding exercise, and we'll give her 3 months' time to. But we will make it absolutely that no adjournment on any ground can be sought by the land losers or
Contending parties.
My
this application pertains to the perceived excess consideration having been paid to the erstwhile landowners for acquisition of land in Umroi for the extension of the airport there. Full stop. Paragraph. An order of the Supreme Court of August 2, 2017 required the Chief Justice of this court to nominate a district judge to determine the following: colon, next line, 1, whether public money had been squandered by offering high rate of compensation which was against the rate offered by the owner and the rate at which she purchased just before acquisition, full stop. Next line, 2, who is entitled to the compensation, full stop. Paragraph. The relevant inquiry, IN, was directed to be conducted by the then District Judge Riboy, full stop. A report was filed by the relevant district judge dated November 27, 2017, full stop. Paragraph. In course of the present proceedings, this court had the occasion to look into the report of November 27, 2017 and, in the order dated November 15, 2022, this court was constrained to observe that the report dated November 24, 2017 was, open quote, singularly lacking in the answers to the 2 issues raised, full stop. Paragraph. The relevant order of November 15, 2022 went on to record that the concerned district judge merely confirmed that there was excess payment without applying his mind to ascertain the quantum of the excess compensation paid, or even to make an attempt to determine or identify the rightful persons who were entitled to the compensation. Full stop. Paragraph. Certain other aspects of the matter engage the attention of the court, particularly since the initial compensation had passed through the officials, passed through the hands of two officials. Full stop. Further, one Patricia Nongsage was required to keep a certain quantum of money in her bank accounts by an order, by the Supreme Court order of August 2, 2017. But it transpired that some of the money may have been withdrawn from such accounts. As far as the two officials were concerned, directions were issued for them to file their affidavits of assets, since such officials would be required to be penalized for having paid excess compensation, if any, to the private landowner for the purpose of the acquisition of the land. Full stop. The three paragraph. There are three principal contestants Ms. Patricia Nongsage, Ms. Tide Dakar. Who's the third one?
I'm number 2, my lord.
Who are?
My lord.
Nongsage, Dakar and?
Mr. Maxiraj.
Maxiraj.
Mr. Mac Lingdo Shira.
Mac Lingdo Shira. Full stop. Full stop. All the aforesaid three persons are represented through learned counsel in court. Full stop. Mr. P. Yobin has been appointed amicus curiae. Full stop. The union is represented by learned Deputy Solicitor General.
Airports Authority.
Very well. The Airports Authority of India is represented by the Deputy Solicitor General. Full stop. Paragraph. Now that the presence of the three principal dramatis persona has been secured, the court today gave an option to the three as to whether they would prefer the determination of the quantum of excess compensation, if any, to be before a nominee before whom all the evidence may be led, as may have been the basis for the Supreme Court's order of August 2, 2017, semicolon or comma, whether such parties would be agreeable for the fact-finding exercise to be conducted by this court itself upon the abject failure thereof in the report dated November 24, 2017. Full stop. The three aforesaid parties have accepted that the matter may be required to be looked into by the present District Judge Riboy strictly in terms of the two issues framed by the Supreme Court in the order dated August 2, 2017, to determine whether any excess compensation was paid to the erstwhile landowners and, comma, naturally, if so, comma, to what extent. Further, comma, the inquiry should reveal what amount and to what extent should now be repaid or compensated, and who would be entitled to such repayment or compensation. Full stop. Paragraph. Accordingly, comma, the present District Judge Riboy is appointed, is directed to inquire into the matter afresh without being unduly influenced by the perfunctory report of November 24, 2017, and to receive evidence to determine the factum and the quantum involved, comma, if any. Full stop. The parties assured the court that the parties, comma, particularly the three aforesaid persons, comma, assured the court that they would cooperate in the inquiry and present the best evidence available. Full stop. The District Judge Riboy will proceed to adjudicate the matter in court. Full stop. It will be open to the District Judge not to grant any adjournment to the parties and conclude the inquiry such that the report is made available within 3 months from date. Paragraph. Let this matter appear in the first week of June 2023.
My Lord, only thing if I can point out, Lordship, in course of hearing, Lordship has issued a contempt notice against Patricia Nonsense.
Yes.
She personally appeared. Her contention was this, my Lord, whatever amount was received, my Lord, substantial amount of money, my Lord.
We are not pushing that matter right now.
Lordship, whatever directed, we have deposited the title deed before the registry.
Yes.
But one aspect, if your Lordship considers, a date may be fixed for us to appear before the District Judge.
She will do it. She's a District Judge, Mr. Kurti. Let us respect each other.
Sorry. Sorry.
half the problem is because the High Court does not give due respect to the district judiciary.
All right, grateful.
Item number 2.
As directed by this honorable court on the last
Yes, sir.
occasion.
I mean, with due respect, a week's time may be accommodated.
No, why? What is the matter
Conducting
about?
counsel is indisposed, Your Lordship. The conducting counsel on behalf of respondent number 10 is indisposed.
If there are 10 parties and you take turns to fall in, how can we conduct a matter? This has gone on for a long time. Have you filed a report?
I have filed a report, Your Lordship, and by way of an affidavit.
Very well. The district council has filed a report. What is the date of the report, Mr. Kinta?
Date of the report is 26 November 2022.
No, that's the date of the meeting.
The report is dated. This is the date of the meeting, and report is.
Without the date, date is very important. The district council has now filed a report pertaining to the meeting held in the relevant village on November 26, 2022. Full stop. Since one of the appearing parties seeks an accommodation, let the matter appear a weekends. Paragraph. The parties are requested not to seek any further adjournment. Yes.
Lordship, can I suggest a date?
Lordship,
Because
you can have that report also for this.
Yes. All the appearing parties, all the parties will be entitled to obtain copies of the relevant report from Mr. Kinta.
Lordship, can I suggest a date? Because there's another matter yesterday also.
Yes.
3rd of
March.
March. Thank you.
Yes.
Apply, Your Lordship.
Item number 3. Item number 4.
May it please, Your Lordship. Your Lordship, here actually the appellant was directed to inquire the birth certificate, Your Lordship, to verify the birth certificate.
Sorry?
To verify the birth certificate of one of the respondents here, Your Lordship.
My Lord, they've taken the plea of juvenility of respondent number 2, my Lord, and they enclosed a birth certificate issued from Murshidabad, my Lord. We sent it for verification, my Lord, and the report is that there is nothing on record like this, my Lord. We have filed that.
Put it on paper. See,
We have
over
filed an
here,
affidavit to that,
I am not someone who takes all this lightly. The natural consequence will be perjury.
I have filed an affidavit, my Lord.
You filed an affidavit? Very well.
Your Lordship,
Let us
actually,
see the affidavit.
Page 8, my lord.
Conviction under which provision?
NDPS Act, my lord. NDPS Act.
NDPS.
Not, it was acquittal, your lordship.
Acquittal.
Oh, acquittal.
Oh, yes, your lordship.
How many persons? All
Two, your lordship.
two.
Page 10 is the report, my lord.
Just a second. And where is that certificate? How had he produced that certificate? By way of an affidavit or otherwise?
They filed an application, my lord.
They filed an application? Which page is that certificate? That page 11?
Page 11 is the certificate, my lord.
And you received this Government of West Bengal officer.
Here, your lordship, one
Just a
mistake.
second, just.
Yeah.
A plea of juvenility or the second respondent has been taken in the present proceedings, has been taken in the present appeal filed by the union against the acquittal of the two accused in a criminal case arising under the Narcotic Drugs and Psychotropic Substances Act 1985. Paragraph. In Criminal MC 75 of 2022, comma, an interim application filed by the second respondent herein, comma, a copy of a purported certificate of birth was appended at page 11-12 of the relevant application. Full stop. The paragraph. The appellant has filed an affidavit on affirmed on February 7, 2023. Full stop. A copy of a letter issued by the Office of the Block Medical Officer of Health, Kornoshubarno BPHC, Barampur Block of Murshidabad, dated January 24, 2023, has been disclosed along with such affidavit. Full stop. The relevant BMOH has reported to the Deputy CMOH Berhampur, Murshidabad, inter alia, that, next line, open court, we have not found any government GOVT sign and birth certificate code number in this particular birth certificate, and also the registration number are not found in our documents section. Full stop, close quote. Paragraph. In other words, as per the relevant state government official in the block, in Korno-Suborno block, in Berhampur block, the purported certificate relied upon by the second respondent may not be authentic. Full stop. Full stop. In such view of the matter, the second respondent is afforded an opportunity to establish the veracity of the purported certificate relied upon by such respondent. Full stop. The original of the relevant certificate will be produced in court on the next date. Full stop. Any material obtained to establish the veracity of such purported certificate may be indicated by way of an affidavit to be filed within 3 weeks from date. The matter will appear 3 weeks hence.
With due apology, Your Lordship. Lordship, actually here the birth certificate, the date of registration, Your Lordship, is mentioned 4/5/92. But by mistakenly, like in typical year, Your Lordship, in typed copy, Your Lordship.
Whatever, we have given you time to establish the authenticity, establish it.
Right, Your Lordship.
If we establish it, we have no problems.
Your Lordship. Deeply obliged, Your Lordship.